Presiding Officer, 3 years ago, 2 women came forward with allegations of sexual harassment against the former First Minister of Scotland. They were women who worked beside him and who, like anyone believing themselves harassed or abused by a senior colleague, felt the power imbalance keenly. Because while these things can be about sex, they are always about power. They didn't report it at the time. He was arguably the most powerful man in the country. And as the current First Minister said in her evidence to the committee, a tough guy to work for. But after the fact, those women did come forward, and we now know that a hastily written HR policy on bullying and harassment and its application let them down. It was unfair, unlawful and tainted by apparent bias. It cost the taxpayer hundreds of thousands of pounds and the women themselves untold injury. So much so that 3 years later, it has never again been tested, despite the FDA union telling the committee that 50% of staff told a workplace survey they had experienced harassment by a colleague. It is a policy that's not been changed, revised or amended, and to have a harassment policy that workers are too afraid to use is a tragedy. But one thing that could strengthen protection is to have an open and honest conversation about what went wrong, why it went wrong, and how it can be made better. And that is what the committee inquiry was set up to do. To have the Parliament, already charged with oversight of the executive, to review a system's failure so that we could fix the system and offer the thousands of people who work for the government proper protection in future. The fact that the committee has been hampered at every turn from receiving even basic information in order to do its job doesn't just let down these women all over again, it lets down current and future government employees too. And that is the context of today's vote of no confidence. So let's review the last few months. On the 4th of November 2020, this chamber voted for the following motion: that the Parliament calls on the Scottish Government to publish all the legal advice it received regarding the judicial review into the investigation of the alleged behaviour of the former First Minister, Alex Salmond. Upon its passage, John Swinney did nothing and missed the deadline set by the Salmond Inquiry Committee of the 13th of November to hand over the information. On 25th of November, another motion was passed by this chamber noting the previous vote and calling on the Scottish Government to respect the will of the Parliament. But still, John Swinney did nothing. It took more than 3 months and the threat of a vote of no confidence in Mr Swinney, which had the votes to win, for his position to suddenly change and a promise of publication to emerge. The Deputy First Minister said, "We will release the key legal advice." The first batch of that advice provided incontrovertible evidence of incompetency on the part of the Scottish Government. It included an urgent note from senior counsel saying the judicial review had a very real problem indeed. The issue that had alarmed counsel so greatly was that they had just learned that the investigating officer had prior contact with the complainers. This revelation was so serious that counsel advised as an option, the issue is disclosed and the petition conceded as a result. It collapsed its own case. This raises the question, why weren't counsel told about this information from the start? The investigating officer said during her evidence session before the Salmond inquiry, "I was upfront about the contact at the time." So who neglected to tell counsel this vital piece of information at the beginning of the judicial review process? Perhaps the minutes of the consultation from the 11th of September, near the start of the judicial review, would provide some answers. Well, we don't know, because John Swinney will not release any details of that meeting. And despite these damning revelations, the evidence that was released on the 2nd of March, the only legal advice we got to see before the First Minister's appearance at committee, was incomplete. John Swinney would go on to release 11 further documents regarding the judicial review after the First Minister's appearance. 11 documents where the First Minister could not be questioned under oath about these pieces of evidence. One piece, the email chain from the 6th to 7th of December, refers to the First Minister questioning counsel advice to concede the judicial review. If the Scottish Government had taken this advice on the 6th of December and conceded, it would have saved the taxpayer hundreds of thousands of pounds in legal costs. John Swinney withheld this information about the First Minister until after her appearance at the committee. And despite dragging tranches of documents from John Swinney for fear of his job, there still remains key omissions. Mr Swinney will have lots of time during his own time to address these points, and I'll let him get on with them when I sit down. He won't take mine. On the 25th of October, the 2nd of November and 13th of November in 2018, the First Minister was represented either in person or by a member of her staff at consultations with counsel regarding the judicial review. In Friday's letter to the Salmond Inquiry Committee, Mr Swinney doesn't mention the 25th of October meeting at all, and he claims that no minutes exist of the 2nd and 13th of November consultations, the latter of which the First Minister attended herself. It is inconceivable that minutes were not taken at a meeting between the Permanent Secretary, the First Minister and the First Minister's Chief of Staff with senior external counsel. And what about the other consultations from the 11th of September 2018, the 23rd of October 2018 or the 3rd of January 2019? No minutes or advice from these consultations have been published either. These omissions in the published evidence make it clear the key legal advice that the Deputy First Minister promised has not been provided. In a note from Council on the 17th of December 2018, they mention a consultation that took place on the 10th of November. Not only have we not been provided with any notes from this consultation, but it doesn't even appear on the Scottish Government's timeline of the judicial review. And who provided that timeline? John Swinney, in a letter on the 26th of October 2020 to the Salmond Inquiry Committee. No wonder the committee has written again to the Deputy First Minister to say it is extremely frustrated and not reassured that it has received all the relevant information. We back the committee. Presiding Officer, we know we won't win today's vote of no confidence. The votes are there for the Deputy First Minister. But we believe that it is important and right to put on record that this is no way for the Scottish Government to treat this Parliament. And while Mr Swinney's outliners will, I'm sure, do a lap of honour in the press, the real losers are Scottish Government employees who have been lumbered with a protection at work policy that everybody knows is damaged goods and that staff are too afraid to use. With a bit of transparency and candour, the committee could have helped work out what went wrong and why. But John Swinney preferred to keep evidence secret at every turn. In a particularly damning note from the 17th of December, Council told the Lord Advocate they could not advise the court that the Scottish Government had discharged its duty of candour. With the way the release of legal advice has been handled, we believe that John Swinney and the Scottish Government have failed in this duty once again. I move the motion in Miles Briggs's name.